against its use. It, however, proves no such thing. In 2005, 12 out of the 50 states banned the death penalty for all ages. Out of the remaining 38 states, 19 allowed for the juvenile death penalty. This is exactly 50%, a figure that shows neither a consensus in favor of the juvenile death penalty nor a consensus against it. The very fact that many states allow for juvenile death penalty but do not ever use it proves that juries are able to take youthfulness into account when appropriate. This inevitably proves that due process of law is being afforded to minors under the age of 18. Since the juvenile death penalty is only judiciously applied in extreme circumstances, for the most heinous of crimes, eliminating the use of the juvenile death penalty altogether is unnecessary. Formulating a top-down, one-size-fits-all approach undermines the due process of law by limiting juries. Yes.
You're talking about a top-down approach, but you're meant. What you're saying is that states should control, when to apply the juvenile death penalty. Is that correct?
Yes, I think that.
Okay. So if you're saying that the state should control it, and the few states that have been giving out juvenile death penalty, a few like Texas, Oklahoma, they have a history of not protecting civil rights. Should we be trusting those states to hand out the juvenile death penalty when they have that history?
I would trust the fact that they have due process of law in their systems, and I would not discount the fact that they, because of the previous actions, that they cannot afford due process where it is necessary. Okay. Formulating a top-down, one-size-fits-all approach undermines due process of law by limiting a jury's ability to use their jurisprudence on a case-by-case basis. For centuries, juries have been able to effectively weigh aggregating and mitigating factors when determining sentencing and innocence. A ruling in favor of the petitioner would undermine the foundations of our criminal justice system and would proclaim the Supreme Court as the sole national arbiter of our nation's moral standards. This is a position that the Supreme Court should not have. Instead, since there is a lack of a clear national consensus on the issue, it should be left up to the states to decide. States are allowed to develop their own penal codes, so it would be logical. Oh, yes.
Sorry. So you said that there's not a clear national consensus, but exactly what percent would you qualify it as being a clear percentage? I mean, in our elections, when we have a majority of the votes, we say that that's a clear national consensus that a certain candidate should be president, right? So when 69% of Americans oppose executing juveniles, isn't that a clear national consensus that people are against the death penalty?
Well, in previous Supreme Court cases, they determined that the best way to prove a national consensus is to look at state and local laws. 50% of the states that allow for any type of death penalty allow for juvenile death penalty. So that means 50% allow for juvenile death penalty and 50% do not allow for it. That proves no clear consensus in that regard. Yes.
Even for states that consistently give out the juvenile death penalty, there's still a discrepancy between juveniles who are on death row and those who actually get executed. What does this say about the effectiveness of the juvenile death penalty?
I'm sorry, I couldn't hear what you said.
Even for states such as Texas that are consistently giving out the juvenile death penalty, there is still a discrepancy between juveniles who are on death row and those who actually get executed. And those who get executed are a lower number than those in death row. What does this say about the effectiveness of the juvenile death penalty?
Well, I would say that it is effective, that the application of the juvenile death penalty is appropriate, and it shows that juries are able to weigh mitigating factors such as age when appropriate. The fact that there's a few number of juvenile executions, 22 in the past 37 years, proves that due process of law is being afforded to these individuals. Yes.
Wouldn't you say that when we discuss a national consensus on the juvenile death penalty, that we have to take into account not only the hard numbers, but also the direction of change? In 2003, 14 states introduced legislation to ban the juvenile death penalty. Clearly, this shows a direction of change that, under the evolving standards of decency doctrine, should ban the death.
That change was directed by the Supreme Court. Like, they changed those states, which led factor that led many of those states to actually change their laws was a ruling from the Supreme Court. And all right. Okay.
Did you say 2003?
Yeah.
In the states that do apply the juvenile death penalty, they use it so sparingly. Would you think that this confirms that it's not being used capriciously or arbitrarily, and due process of law is being afforded to these minors?
Yes, the fact that it is rarely applied shows that it is only that due process is being granted to those individuals. thank you for our time, and we hope you make the right decision.